Good evening to all our students and welcome you to attend our second student gathering. Tonight, the theme is to share with you how to study for the CGQP modules about law, governance, and compliance modules. So tonight, we are very pleased to have Dr. Davy Wu, one of our assessment review panel members, to join with us to share on the examiner's comments on the four subjects. So for tonight, we will look into the topics in, I'm sorry, I have to read. This is the rough program of tonight's agenda. We'll firstly look into the CGQP, and then we will talk about what do you know about the modules. This will basically about the examiner's comments on the performance of the November examinations in last year. And then we'll have a few feedback on the performance of our students with the survey we've done after the examinations. And then most important of all is that how to prepare for the forthcoming examinations. And then we give a highlights of the important dates before we end tonight's sessions. So the next is that about the CGQP program. I think most of our students, if you have already registered or take examinations, you will know that the CGQP was launched in last year, January 1st, and then it divided into two parts with 4 papers each. And then part 1 is about the core fundamentals, is the corporate governance, corporate secretaryship and compliance, Hong Kong company law, and that's the interpreting financial and accounting information. This subject is interesting part is that it's a combination of our old syllabus of the financial accounting as well as corporate financial management. But this subjects in the new CGQP, we don't look into just calculations. We look into more of the keyword interpreting. And then in part 2, we have the strategic management with 2 new models, risk management as well as boardroom dynamics. And then also with the Hong Kong taxation. Whereas the boardroom dynamics and the Hong Kong taxations are elective. So under this CGQP models, you just need to take 7 modules, papers. And then I would like to share with you some of the special features of this CGQP. Already, we mentioned, is launched in last year, January. It is an internationally recognized program, which the examinations are adopted by 5 CGI divisions, our international body, with the local adaptations, including Canada, China, that is HKISS, Malaysia, Singapore, and the United Kingdom, including Ireland and the related territories. So you will see that the new papers in the November is a little bit different from what we used to be in the IQS. And then this CGQP exams have more of the international perspective with local adaptations. We have more focus on compliance and risk because completing this, you will become a member as chartered secretaries as well as the chartered governance professional. And we have a more strong case study approach. All the with the part 2 papers, the 3 modules have a pre-release case in 6 weeks. So you have time to read the case. And that, as I've already mentioned, is a 1 qualifying program and leading to 2 membership qualification from CGI as well as HKICS. So when we look into this programs, the CGQP program, most important of all, I will advise our students who are intending to study this examinations, look carefully with details into the syllabus of each modules. The key features, if you think that I would like to have some guidance, I will advise you to look into the detailed briefings on the CGQP syllabus videos, which we have taken in last year when we first launched. So there are 2 sessions as well. So please visit our website at the studentship of the activities and events. You can look into these videos. And then for this syllabus, I would advise you that because this is a professional examinations, you will find that we have more subject matters to assess. That is, all these are more relevant to our day-to-day work. Is in the exam the professional practice. So you'll find that most of these syllabus have detailed descriptions from 300 to 400 points or items, which is very different from the old syllabus. It's just a general description. And that we advise all our students who haven't taken any of these subjects before or learning before, we advise you should prepare for 200 hours at the minimum from the first reading of the syllabus until you are well prepared to enter into the examination hall. 200 hours is the key. And then for students who have registered with us or just in last year, the CGQP examinations with that 7 modules that we give you 6 years to complete. And that because we understand that a lot of our students, I think is over 99.9%, are working adults. You have to work, you have your family, and then we allow you to extend to a maximum of 4 years. That is 10 years as a maximum. If you can't finish, then you cannot extend your studentship. So all these 10 years rules is applicable to all students who are on the register from 1st January 2020 onwards. So you will have enough time to complete your examinations. And then we look into, some students will say that it's very difficult. Why? Because we have a very stringent quality assurance structures. Each of the modules will have a chief examiner, a reviewer, and then with a group of the papers, we have the review group chairs to review all the question papers as well as the mark scheme. And then after the examination, after all mark scripts are reviewed, we have the post-exam review by our assessment review panel and then submit to the education committee. So this is a very stringent 3 tiers review from starting to end. So that's why we prepare our students to become professional charter secretaries as well as charter governance professionals. And then also under this QA, we also have to be up to date and be valid for the governance professionals. So we will have annual module level review. We review the syllabus, and then we review the study materials as well as the reading list. And then we have from time to time, when required, the program level review. And then not just the syllabus, as well as that whether we need to modify or make changes to the modules, as well as the study materials together with the exam paper structure and format. So this CGQP is the product of this program level review. And that with all the international divisions, we did it almost for more than 4 years. And about the CGQP syllabus, I would like to remind you that we have made some updates in last December as well as October. So I'm not going to look into details, read our news as well as go to the syllabus sessions. All these can be found, what's news. And that you have to keep abreast with all the notices or the circulars or the emails we send to you, because it will affect you to whether you are familiar with those topical issues, with the changes. So when it comes to the CGQP examinations enrollment in last November, and then we said that because it's unfortunate that we have the COVID-19 in last year, we have postponed the June examination. So this November 2022 that is our first examinations under the CGQP. And you may note that our cornerstones subjects, the modules, corporate governance, corporate secretaryship, as well as the Hong Kong company law, we have most of these students have to attend because a lot of them cannot have the exemptions. So about the modules, I would like to remind you about the examination paper structure and format. For part 1, corporate governance, Hong Kong company law, as well as corporate secretaryship and compliance, all are in a 3 hours papers divided into 2 sections. The first sections composed of 5 questions each carry 5 marks. They are all compulsory. You must answer all questions. And section B is composed of scenario-based and non-scenario-based questions. Each carry 25 marks, and then it will complete, you have to complete 3 out of 4. So a total of 100 marks. And then for the part 2, about the boardroom dynamics, which is also one of the key subjects in this tonight's sharing, it has a pre-release case about 3 to 4 pages. We will send to all the candidates 6 weeks ahead of the examination date. It's also a written examinations of 3 hours with 15 minutes reading. And all questions, the candidates have to answer 4 questions in total, including the pre-release case with 75 marks from 3 out of 4. And that is also 25 marks each. And usually these 25 marks will be split into part A or part B. And then the section B is not based on the pre-release case, it's single, and then you have to answer 1 out of 2. So when you look into this examination format, you will see that it's quite difficult to guess what we are going to assess you. But I can assure you that most of what you have to be tested in these examination papers are mostly practiced by the practitioners, because we need to know what you understand when you are in your workplace. So about the performance of the candidates, we can look into, this is the statistics we've done, where we compare those students who have attended certain of the tutorial class, the learning, or the examination technique workshop, whether it is a live or a video one. You can see that most of the performance, the passing rate, is higher than those overall one. We can't say that, like, for example, the technique workshop, just a 3 hours learning can be helpful to your study to pass. But it hints that all those who have attended these learning support events, they have spent enough time for their study, and they have some clue to how to prepare for the examinations. And so when it comes to the examiner's comments, we have a very long discussion, as you see, we have under the quality assurance model, that most of our examiners have the comments like our candidates need to read examination questions carefully, because a lot of those requirements, they will require the candidates to write a report, write a memo, or write a policy paper, but all these formats are neglected. So you can't earn the marks. You're giving marks away. Or you didn't time your answer for the answers, and you spend too much time into one questions. And that for certain modules, we have already emphasized is that there are certain pre-release case, and that you need to read the case in details, and then try to understand all those facts and try to interpret what will be the issues in your subject matter, in your module. For example, risk management, or the strategic management, or the boardroom dynamics. You have to refer to those syllabus or some keywords where it can give you a clue. Questions may be asked, or weaknesses, or features that there are certain things will happen in this case, and that you can better prepare for your answer. And also that they will advise the students have a better full coverage of the syllabus, because when you look into the exam structure, you can't just study 1 or 2 areas. you don't have enough knowledge to get your marks. So prepare your study plan, and that make sure that you have good foundation knowledge on each of the modules which you are going to apply for. And there are certain examiners' comments, and indeed these comments we have sent the emails to all the candidates in this year. It reflects most of what we have mentioned in the previous slide, but we do understand that because this is a new exam scheme with new syllabus, with changes in the examination format and structure, and of course, I'm sorry, we have a typo here, is the impact of the COVID-19, and that it may affect your preparation. But I can assure you that all the examiners give the same comments. Candidates who had prepared well perform well at the examinations. And those who have a lower grade, usually is that in reading the question papers, they can't identify the issues being asked. They are not answering the questions properly, or most of the time, candidates just write what they know about without answering, and just let the examiners, you make your own choice. Of course, then you can't get marks. Or that you don't follow instructions provided in the outline, or you don't plan your answers. And also, you give away marks because you don't give a report or a memorandum or policy paper as a format required. And about the case studies, just the same thing we've mentioned. But most important is that spend time, study the case details before the examinations. You need to know the facts, because if you just enter the examinations, you don't have time. And then you don't have time to analyze. And remember to prepare some possible lines of questions and broaden your thinking before you enter the exam hall. Of course, we can't tell you what you will be examined. And finally, is that when you prepare for your examinations, you have to read the study materials well, because I can assure that in our quality assurance, all examination questions with the answers, it can be found in your study outline. And then we have a syllabus script to control this. And also, some students just memorize the past papers because you just memorize the IQS, but it doesn't fit for this CGQP. IQS can give you as a reference, but the context, just like I said before, it's look into more practical issue, and that relating to the theories in the scenarios of the questions, and that you have to cover the full syllabus, and don't just pay attention to certain hot topics. And most important of all, answer the questions, and you have to apply theories or concepts in your writing and in a practical way. So here, I'm not going to look into full details of certain of the descriptor, because in our exam papers, how you get distinguished from a fail for each of the questions, fail, pass, or merit or distinction. That is where your grades come from. We have these descriptor indicator in each of our suggest answer, that you will find these in your papers. So read them carefully. It gives you the ideas how our examiners grade your scripts. So this is what we want to talk about. So by going to this, I would like to turn to our speaker tonight, Dr. Davy Wu. And that we have 4 papers, and that we have given a summary of each of the questions, as well as how the examiners give their comments on the answers of our candidates. Can we just maybe we start now on the Hong Kong company law, and then we'll just let Dr. Davy Wu to walk through a bit of these comments with the questions. So I'll turn the time to you, Dr. Wu, please.
Thank you, Louisa. Well, ladies and gentlemen, thank you to this webinar. Well, it's very good to start with the Hong Kong company law because, in my opinion, Hong Kong company law, or generally company law, actually is a mother of all in corporate governance. Because why we need to study corporate governance is because company law has created company this legal form. Okay, so I think I will spend in this part I will spend more time on Hong Kong company law because once you actually comments here can be applied to other subjects as well. Well, for example, the general comments. Well, shall we look at the second one?
Okay, I'll do it for you.
Yeah. Oh, no, we are still on that. Thank you, Louisa. Slide 2. Shall we go back to slide 2? Okay. Well, the examiner found that many candidates, they fail to identify issues. Yeah. Well, that's very, very important. Well, ladies and gentlemen, look, for a question, it is quite rare for a question to have just one issue in it. You can expect 2 or maybe 3. If you can say provide a world-class answer to one issue, well, it's not going to help because you have to perform equally well on both issues. So that's why sometimes after examinations, when people they left the exam hall when they talk, maybe all people they thought that, well, I have been doing well. Mm-hmm. But why it turns out that, well, not all are going to pass is because you missed out one issue. Yeah. And you didn't know it. Okay, so that's why I think that here the examiner has put down a very, very good comment that well, many candidates they fail to identify the relevant issues. And the next problem is, I think it's the other side of the same coin. Since some candidates they fail to identify the issues, and those candidates they be under an illusion that, well, I thought that is an issue, but actually it is not. Okay. Well, it is my experience that not just for marking professional examination papers, I saw the same in the campus. That many students they always thought that directors are the root of the problems. So whenever they see directors being mentioned in the case, they would think that, well, look, I think the directors must have done something wrong here. So that's why all the questions I would see people saying that, well, the directors must have breached, well, this or that duties. Yeah. Well, maybe that is not the case.
Yeah, there may be other senior officials.
Right.
And the officers.
Right. Yeah. So directors, they are not always the bad guys.
Yeah. They are not the devils. Okay.
But it is true that many students they always think that directors they are the usual suspects. Okay, and well, the last one, many students candidates they would just jump to the conclusion without actually explaining. Yeah. Well, again, it's not just I think it's common to examinations inside and outside the campus. Many candidates they were able to put down the relevant legal principles, okay, in a professional way. Yeah. But then at the end, they just jump to the conclusion without actually explaining why they arrived at that conclusion. And even worse is, they did not address the facts in the question. Okay. Well, actually, Louisa made the same point earlier. Many candidates, they did not actually analyze the facts. They didn't actually address the facts. Okay. And then now you know that, well, from Louisa's explanation, you know that we have a very, very sophisticated process for fixing, for writing, for approving the questions. Yes. So we won't put well, irrelevant things into the facts. So there must be a reason why we put such facts into the questions. Yes. So if you found that, well, I have nothing to say about the first paragraph or second paragraph, I think you're in trouble. Yeah.
So all the hints are embedded in the questions
of
the case.
Right. Well, for example, in company law, well, once in maybe 1 or 2 years, you'll see a question saying that, well, Amy, Betty, and Candy, where they were friends, they first start out in as partners, and then they incorporated the company into a company. Yeah. Well, there is a very important implication here. The question is telling you that this company is a quasi-partnership company, and the shareholders' interests will be more extensive. Okay, so well, shareholders of ordinary companies could enjoy. Yeah. So this is it is not just one way of telling you a story.
Yeah.
It is telling you that this company is what is a quasi-public company, and you know that there will be important implications regarding just an equity winding up and also unfair prejudice remedy. Okay.
So there are hints.
Right.
Hints is important.
Yeah. So if you ignore the facts, well, you are what? You are throwing marks away.
Yeah, giving marks to the examiner.
Right. But examiners, well, of course, they cannot cash in on the marks. They would want to give you marks, actually. Yeah. Okay. Well, so the examiner of Hong Kong company law has made these suggestions. Read the questions carefully, especially the facts. Okay. Remember. Especially for section B, you need to apply the principles to the facts in order to provide analysis, and that analysis will lead you to the correct conclusion. Well, as a teacher myself, I would care more about the analysis. I care less about the conclusion. Well, ladies and gentlemen, the facts, no matter how clear-cut they are, the facts will not span over pages. So there will be white spaces between the facts. So sometimes maybe the examiner would come across a case that, well, this candidate has understood the facts in a different way. But that interpretation itself is reasonable.
Yeah.
So perhaps the conclusion is different from what the examiner would have in mind.
Yeah.
But still the analysis is first class and the conclusion is proper based on that interpretation of facts.
Yeah. So I would just add, because Dr. Davy Wu is a company law professor. He taught in his university. And I would like to say that, please remember, in all legal cases, we have plaintiff and defendants, always with two sides. Yeah. So you have to think two ways. And then how you can see advise what the benefits and the costs or the liabilities of those people in that case. Yeah. So, should we move on?
Yeah, sure. Okay. So
section 1A is the short questions.
Yeah, I think we can be brief here.
Yeah.
Well, section 1 is testing your knowledge.
Yeah.
So well, frankly, the more thorough is your preparation, the more likely you are going to perform well in this part.
And you can get high grades.
Right. Well, this one, question 1, simple. Okay. Many candidates, when they are studying the powers of liquidators, perhaps they did not pay attention to the fact that some powers could be exercised without the court approval or without the approval of the committee of inspection.
Yeah.
And question 2, well, this one is interesting because it asks how the remuneration of the executive directors will be decided, and here. Sometimes, it is good to study the model articles. Ladies and gentlemen, if you go back to Schedule 1 or Schedule 2 or even Schedule 3 of the model articles, which is an appendix to the company's ordinance, you realize that the model articles state that it is the shareholders or the members in general meeting to decide. Okay, the director's remuneration. But we also know that in practice, especially among listed companies, the chairperson of the AGM would request the shareholders to vote for an approval, so that the board can fix the remuneration with the directors.
So it can have more than one answers.
Right.
And this question is quite tricky because it didn't mention is a limited company or just a private company.
So that's why if you have knowledge of Schedule 2 or Schedule 1, this is an edge.
Yeah.
Because the model articles actually has talked about that point.
Yeah.
Okay. Well, this one I think is just simple. We all know why the fixed charge is more welcome by the bank, because fixed charge can give a higher priority.
Yeah.
So this
is
a
protection to the bank.
Right. Well, the fourth one, how to pass resolutions. Well, the key is private companies, they can make better use of the written resolution procedures. And here you see that, the examiner found that some candidates, they waste time on talking about notice of meeting or how to call a meeting. which is not relevant.
They talk about procedures,
Right.
but not the methods.
So that's why Louisa said, advise you that, well, please read the question carefully.
That's the way how we look into questions, highlights the keywords.
Right. And well, the third one, well, is straightforward. Okay, if you have studied, then well, you know the answers.
Yeah, but the examiners also mentioned that students maybe just give what they know. They just explain the detailed rules, but this is not relevant to the questions.
Yeah.
So that you see that those with a cross are the don'ts, wrong answers.
Okay, section B.
It's about the cases. The
wrong
questions.
Yeah, removal. Well, this stuff supposedly is straightforward because you just need to what? You just need to state the procedures. But you can see here, the examiner found something very, very, I would say, peculiar, because apparently some students, they were under the impression that it would need the making of a special resolution to remove a director. Yeah. Well, frankly, it was a legal position long time ago.
Yeah, but it's changed.
Yeah, it's changed for many years.
Yeah.
Okay. So sometimes I wonder whether some candidates they have grabbed some very old editions of textbooks from the public library. So that's why they were making this silly mistake.
Our old exam papers. So please study your online study materials. Keep yourself topical.
Yeah. Well, law is changing every day, ladies and gentlemen. Well, it is no exaggeration to say that law actually is developing on a day-to-day basis, because company law heavily relies on case law, and the Hong Kong judges, they can refer to case law created in other jurisdictions.
Yes.
And so that's why you have to pay attention to the development. Well, here I think I can digress for a few seconds. Well, I would suggest the candidates to consider. Well, subscribe to the newsletter of some local or international law firms or account firms, because they will prepare newsletters to inform the readers of the latest developments, and those subscription services usually for free.
Yeah, or that I would advise our students just pay attention to our CPD seminars. Yeah, and then we also give topical changes, updates in those CPD seminars.
Well, I imagine that. When you are, say, on the way to office or on the way home, and when you are stuck in a very packed MTR or train, well, you can read the newsletter on your phone. Yeah, I think it's one way to prepare yourself for the examination.
Yeah, that's it.
And 6B. Well, look, the problem here is, there are many candidates, or at least some candidates, a number of candidates. Well, they think this question is about statutory jurisdiction. And in fact, throughout this paper, the examiner found that many students they put down SDA. So I think one reason is that some candidates, they have prepared, they only focus on some hot topics. Yeah. So they thought that, I think maybe one or at least maybe one or two questions will be about SDA. Yeah. So they just put down the thing they knew in the answer without actually reading the facts, without actually reading the question.
Yeah, but I think these questions, Dr. Wu, say that unfair prejudice conduct is quite common in winding up. Yeah, I think so. Don't select your hot topics. Your hot topics doesn't mean our purpose of assessment.
And you never know. Maybe one topic has been put in the past 2 or 3 years in a row. Yeah. Maybe this year the examiner we want to test the candidates of some new things. Yeah,
but I will say that we are forward-looking. We thought professionals need to be current with all the changes. So we will not tell our board, our senior executives, the old things, because it's wrong.
Well, 7A. It's a very typical question about a comparison of partnership and company. But the examiner found that some candidates, they write their answers on based on well, limited partnership.
But it's not within our syllabus.
Mm-hmm.
We haven't announced to test on the limited partnership. It's only this December we inform our students. So please read our information. And
well, think about it. It doesn't make sense.
Yeah.
If in limited partnership, one person will enjoy the limited liability, but the other cannot.
Yeah.
So who is going to bear the general liability?
Yeah.
So I think a more sensible option is that they either remain as partners, or they will simply incorporate the business into a company, so that everyone as shareholders can enjoy limited liability.
I think they can advise if there's a limited partnership, but it will create more problem. Then it can give answers. Maybe with the others, then he can do a better answer.
Well, this one is was straightforward. I don't think we have to spend time on it.
Okay.
Okay. Well, 8A. Well, one glaring mistake here. One glaring mistake here is some candidates they write on section 465.
Okay.
Well, section 465 has nothing to do with fiduciary duties. Okay. So it is pretty much a waste of time.
It's a wrong interpretation.
Right. And I don't know why. Otherwise, but some candidates would think that it relates to financial assistance.
Yeah. So, Dr. Wu, maybe I would just like to ask, because sometimes if there's like a fiduciary duties, or maybe in futures, it's touch on the reasonable care, skills, and diligence under sections 465. If a student cannot quote exactly that section, but can still explain these facts, marks will be given, right?
Well, when I was studying the institute as examiner,
long time ago.
Yeah, long time ago, when you were a kid, I would give marks because I think most examiners, if not all, they are very sensible.
Yeah.
They would be sympathetic with the candidates. If the candidates can provide a very sensible analysis, I don't think the examiners would care about the section numbers or the case names.
Okay.
Well, again, you see SDA here. This question definitely has. I couldn't understand why some candidates would think that there is any reason to think it could relate to SDA.
Yeah. Is it SDA is a hot topic in this 220?
Maybe.
In their practice.
Maybe.
Okay, we come to a case.
Well, you see that the examiners here comment that again, the candidates they talk about SDA, which is totally irrelevant to the question.
So we noted that this SDA has appeared in at least 3 different questions, and then answered from the students. So, what's the conclusion you would like to give to our students in this paper? In studying this company law, it may be students that haven't studied company law before, because it's a very comprehensive, lot of materials, and then how to start, or that it can help them to at least relate the subject matters.
Well, one trick and also obvious suggestion is that you prepare yourself well. Okay. Well, I know that you're saying very different. You are talking something that my father has been telling me for 20 years.
Yeah, when I was a kid.
But it is still valid. It's still valid. Why? Look, I think when Louisa told you that you are going to spend at least 200 hours on each paper, you'll be thinking, wow, it's quite a lot. But ladies and gentlemen, look, Hong Kong company law, if you can do it well on this course, you will find corporate governance, you will find BD, board dynamics, easier to understand.
Or even the CSC.
Right.
Because it's the cornerstone to help you.
Right.
But I would just like to remind our students that actually in last year we have invited Dr. Davy Wu to give 2 parts of company law, just like in a nutshell. And he has grouped them into very sensible sections, so that when you look into those then you understand how why we have this company law, and that the duties, liabilities, or what should be done by those directors and officers. I think these are the keys. So if you have time, then you can subscribe those videos and spend 4 hours, have everything in a nutshell. It may help you to understand this company law subject matter.
Right.
Okay? Yeah.
Okay, shall we move to CSC?
Thank you.
Well, I think CSC, the comments are very straightforward. So I don't think we need to go through them one by one.
Yeah.
But I want to take this chance to explain to you why, if you spend more time on Hong Kong company law, well, this strategy will pay off.
Yeah.
Well, for example, corporate interest. If you have understood the concept of corporate interest well, and then when you move on to CG, you find easier to follow the logic, okay? Because, under company law, you know that you need to disclose your corporate interest, okay? It's a legal duty, because otherwise you're subject to a fine. And then when you move on to CG, and then, the next step is how the directors should consider the issue of conflict interest.
Yeah.
Okay, and we know that under the CG code, the CG code say that if the board is going to consider a director's conflict interest in the contract, the board must have a physical meeting.
Yeah.
And it is not allowed, according to the code, it is not allowed to make a decision by written resolution.
They must meet and discuss.
Right.
Consensus at
Exactly.
the meeting.
Right. And when you move on to CSC, and then the conflict interest will present itself in a new dimension, and that is connected transaction. Okay. So that's why if you have laid down a good foundation stone in Hong Kong company law, and then what follows in CG, in CSC will be just natural.
Yeah. That's why we always said that these 3 papers are the golden triangle.
Right. Right. So
they relate and link to each other, and supporting the CG of your company. Okay,
so I think the comments that the examiner of Hong Kong company law has made will also be applicable here.
But this paper with this comments from the examiner, I think is that the students, our candidates needs to grab some better legal concepts, because a minor shareholder is not a minority shareholder. I think these are fundamental legal concepts. That's why we said that you must read and study your study outline. Don't pick, no cherry pickings for the topics. You can't. You just give a wrong answer.
And speaking of the technical terms, and sometimes, you might have mixed up the concepts without even knowing it. For example, the listing rules and the SFO, the Security and Spiritual Owners, they have defined the term substantial shareholders differently.
In different ways.
Yeah, right. The term is the same, but the definitions are different.
Yeah. So we still have to put time to study.
Yeah. So I know it's a very obvious, very obvious recommendation, but still the most important recommendation is you prepare well for the exam.
It's the gold standard.
Right. Okay, so this one, I think the examiners state that this answer is well answered, it's very popular, and it talks about the blackout period. So apparently most candidates, they know that certain days before the announcement of the results, the directors cannot buy or sell shares. Okay. Well, here relation on this question 3, and the examiner had noticed that some candidates, they have mixed up transmission of shares with transfer of shares.
Still go back to the fundamentals, the definitions.
Right. Well, top-up placing. The examiners here comment that apparently many candidates, they do not understand the meaning of top-up placing. I think in Chinese it's a 先教後生. Okay, and well, maybe you don't find it in the listing rooms, but it is a market practice. Okay, so that's why I think it's a good idea to subscribe to the newsletter of the local law firms, or to the not just local, I mean the reputable law firms, the reputable account firms. And in fact, if you even go to the SFC website, SFC at their investor education website, I think they have a section. I think they have a page called the Chin's Family. And in fact, there was a web page on top placing.
Yeah. Okay. So you still need to have some more extensive reading.
Well, you may be disappointed to have heard me saying that you have to read this or read that. Well, ladies and gentlemen, I don't think here my role here tonight is to perform any magic to cut short the path.
Yeah.
The path is still long. Okay, but hopefully Louisa and I tonight are leading you to the right direction.
Yeah, yeah. And then we're just giving some highlights that commonly found, some problems or issues found in the answers, so that you were aware of this.
Well, question 5, well, it's about board evaluation, and whether such evaluation results should be publicly disclosed. Well, the second part obviously is very straightforward. If you have done it, well, you should disclose it. Okay, because by doing so, you are telling your shareholders, you are telling the stakeholders that you are following the best practices all over the world.
It's the transparency.
Yes, and the key word here is discuss why.
Yeah.
Why it is necessary.
Yeah.
Okay. Well, I think some candidates would simply put down in the answers that why we need to do it because it is a recommended best practice. Okay. In the code, but I would imagine that a better answer is what benefits, what evaluation could bring to the board. If we just said that it is because it is recommended by the CG code, it is not very different from what? From telling the examiners that I did it because my father and my parents asked me to do it.
Yeah.
You have to know the rationale. You should be able to explain the rationale.
I think it's put in practice. You just can't tell your board that because the stock exchange wants you to do it, but you have to explain what benefits it will bring to your company. Then that is why we have to do it, and then we have how to do it, and then where to inform and who to inform. So I think it's always look into these whatever we call the 5 Ys, 7H, etc.
And I believe that this question has done a job here. What job? It is emphasizing the importance of board evaluation here. Well, to some degree, it is a shame that Hong Kong CG code does not make this a code provision. If you look around your shoulder, if you take a look at this UK CG code, well, the Australian CG code, well, board evaluation actually is required. So I think this question has done a good job here, and that is to preach to tell the candidates that look, this is important.
Yeah, and also I think I can add lib to it is that in your study materials from time to time, we also have the UK practices and certain international rules or guidelines. And then students, I think you can refer to those, not just on the Hong Kong, because Hong Kong sometimes is the follower. We don't lead, but we follow. And then it helps you to give more sensible answers. So just read some of those international rules or policies. And then it helps you to think more. And you may also find this in our online student materials. Okay.
Oh, before we move on, one obvious reason why every board must do evaluation is that when AGM comes, when it's a time to consider whether an existing incumbent director should deserve another term.
Election.
Well, the chairperson should ask, has that director been doing a good job in the past 3 years?
Yeah.
And this is what the evaluation of that director can tell you.
It's just like your performance appraisal.
Right. Okay, well, section B. Well, the examiner has noticed that apparently a number of candidates did not really analyze the questions well, and cannot apply principles to the facts.
Yeah. I think this is the common problem.
Yeah, not just
in other
unique to this
papers as
course.
well.
Yeah. Okay. Well, 6A. Well, this one is fine because the examiner's comment that this question is well answered. Is well answered. So I think we can move on to the next question. It talks about what? It talks about why some companies will want to put their company into dormancy. And well, this is a very pinpoint comment. Not many candidates in the exam could suggest the commercial reasons. Well, it is quite what it is. I could understand why the examiner will make this comment, because if you go to any typical textbook, the textbook will tell you what you need to do in order to make the company dormant.
That is the procedures,
right?
But not the reasons,
right?
So
right.
That is. I would like to remind our candidates in future look into what is being asked. Is don't just give what you know. You can't earn marks. And
well, I think there's a wake-up call. It can serve as a wake-up call, because look, this CGQP is a professional qualified examination. Yeah. And once you are qualified, when you have become a full member of the institute, you may be appointed as a concept of a listed company. Yeah. So the board may ask you, well, why should we do it? Not just how to do it. Yeah. They may want you to explain to them, could there be any good commercial reason or good grounds for us to do that? So I think this wake-up call, not just as a concept or as a CG professional, not just you need to know how to do it, but you need to know why. Always explain why. Okay. Question 7? Yeah. About directors. Well, again, the examiner found that the candidates, they are not addressing the case facts. Yeah, the problem. And apparently a number of candidates, they put down things not required, like the resignation procedure. Yes, although this is a CSC paper, but still they would like to ask you about why we have to do something, and then explain, because this will maybe you have to put in your day-to-day work. And then about procedures, I think usually directors would not ask in details, but you need to know about it. But that is why we have to ask students, because maybe that in the past they usually ask what are the procedures if you look into the IQS papers. So I don't mean that in future that we won't ask procedures, but still read the questions, what you are asked to give the answers. And here I want to make a side comment. This question is about appointment of directors. Yeah. And many candidates and many students of mine, they were under the impression that appointment of directors is regulated by the ordinance. But actually, if you go to the company's ordinance, and if you go to, say, the Companies Acts of UK, of Australia, of other common law jurisdictions, well, you may be surprised to know that, well, those laws, those statutes, actually, they were silent on the appointment of directors. Yeah. So how directors could be appointed in your company will depend on your articles of association. Okay, and in fact, it is possible for a company to appoint a director without going through the AGM or GM.
Yeah.
Okay. Well, like what? If you go to the articles of say HAEX.
Yeah.
Well, let's not forget that HAEX is a listed company.
Yeah.
And if you go to the articles of HKEX, you realize that you know that the financial secretary of the government has the power to appoint directors.
Yeah.
So all Mr. Paul Chen has to do is to send a letter to the board of HAEX, and that is how those up to 6 directors could be appointed by the government.
So for companies matters, not just the company's auditors,
Mm.
in particular for CSC, look into your articles. Okay.
And by the way, if you want to find examples of good practices, well, I would suggest you can go to the HAEX website, because HAEX, well, they play an important role in enhancing the standard of corporate governance in Hong Kong. Like what? Board skills matrix.
Yeah.
Now it is board skills matrix is recommended indirectly by the code. Well, why I say indirectly, because if you go to the code, the Hong Kong CG code does not mention board skills matrix. But if you go to a related publication by HAEX, which is called the Guidance for Boards and Directors, you will see that recommendation. The recommendation that the board and also the nomination committee should prepare a board skills matrix to find out what are the existing skills the board would have, and what skills we need to have in the future. Okay, and many students of mine they ask, well, when can I find examples of board skills matrix? Well, simple. Go to HAEX. They prepare a board skills matrix of their own board of directors.
But I think quite a number of those top tiers, the top 10 companies, listed companies, they have their diversity, and then also present the diversity of the board in that technical of the skills matrix. And then you can refer to a number of these annual reports, and then gives you some flavor.
Well, I think, here, I don't want to give names, but we always know that which companies are the poster boys in Hong Kong good corporate governance. When you go to the website, well, you always can get good examples.
Yeah, I think always those top tiers.
So you know which companies we are thinking.
Look for the good ones.
Right. Okay. So again, well, the candidates are not addressing the case facts.
Yeah. So remember to relate your answers to the case, so that you can link your theories, principles, rules to the facts of the case for the analysis, so that it helps you to go to the conclusion. Okay, our third paper, which is the key, the golden triangle, the third one.
Corporate governance. Okay. Well, it's good that, well, here the examiner has something nice to say.
Yeah, very positive.
maybe I think most candidates have taken this course even more seriously.
Yeah.
Well, generally the candidates can show a good understanding of the basic concepts. So here the candidates they can present the answers in a logical and coherent manner.
Yeah.
Well, I think one possible explanation is that corporate governance. Well, we can see it as what? We can see it as the human side of the application of a company law.
Yeah.
So it's more about practices, it's more about processes, and especially our candidates, they are working.
Yeah.
They're working people. So they have seen corporate governance in action.
Yeah.
And for company law, perhaps some concepts are new to them. For example, I think one example is what? I think we all know that in Hong Kong, most listed companies they were not Hong Kong companies.
Yeah.
Okay. So for those Bermuda companies, for those Cayman Islands companies, there's no need to talk about some very local concepts like distributable profits.
Yeah.
But if your company is a Hong Kong incorporated company, well, your company can only pay out dividends if you have made distributable profits.
Yeah.
And perhaps that is something that you have never come across if your company is a Cayman or Bermuda company.
Yeah.
But here we see a different landscape. your experience
Yeah.
will help you to understand this course.
Yeah. I think this is more in practice,
Mhm.
but for company law is more conceptual because talk about rules, statutes,
Mhm.
and whereas in the CSC
Mhm.
is looking to as a CS role,
Mhm.
explain,
Mhm.
advise your board, and then go to the procedures.
Yeah. Okay. So, well, shall we move on?
Yeah.
Go direct to section A. Again, you see similar comments.
Yeah.
Not actually addressing, not actually answering
Yeah.
the question. Well, question 2, describe the board leadership role and function in the governance of the ESG matters. Well, ladies and gentlemen, of course, we all expect you to, when you do a revision, we all expect you to start from the study guide.
Yeah.
But here, if we do you no harm, if you go to what? If you go to the materials prepared by the HAEX.
Yeah.
You know that in recent years, HAEX has taken ESG very, very seriously.
Yeah.
And they have prepared many guidance materials for the board. So if you go to the website of HAEX, well, certainly you'll find many useful materials. Not just they would help you in examination, but definitely they will help you in your practice. Okay, well, here it's just very simple. It just asks you if you're a director, and especially if you are if you are supposed to represent a majority shareholder, well, will that affect your director's duties?
Yeah.
The answer is no.
Yeah.
Well, ladies and gentlemen, have you noticed that this is actually, if you just join us here, right here at this moment, you might be thinking, are we talking about the company law paper?
Yeah.
Because this is a question that you can put in HKCL.
Yeah.
So that's why early on, our recommendation is, if you have spent sufficient time, enough time, or even more hours than 200 on Hong Kong company law, your effort will pay off.
Yeah. But it's under the CGA because when we talk about majority shareholders, and then also of the interest of the minority shareholders, this is the fundamental of the CG.
Okay. Well, question 4. Well, how the audit committee could review and monitor the independence of the audit company's auditors? Okay, and well, what can you do to review and monitor? Well, if you go to the code, you will find many good suggestions. Like what? Like the audit committee can assess whether we have given too much non-audit work to our auditors. So if you go to the code, you have what? You have well, much to write for this question. Well, stress testings. This is a straightforward one. Okay. Well, section B. You can see that the exam has prepared an analysis here. Right. So question 9 must be very interesting.
Yeah. Okay.
So that's why most candidates they would just brush it aside.
Not the popular one.
Yeah.
Not popular by our candidates.
There must be a reason. Okay. Well, provide a summary of the steps that should be taken. Well, when there is when there is what we call common directorship. Well, it is. You may be surprised to know that company law actually would allow common directorship. Okay, you can even sit on the board of a rival. Just the sitting on the board of a rival company is not a wrong. But how can you serve the interest of the two companies is a question.
Yeah.
Is a question. Okay. And well, in the lecture theatre, sometimes the student would ask, well, David, is it legally possible to do that, to sit on the board of the rivals? The answer is yes. But how you can do it without breaching your duties, I don't know.
Yeah. In practice.
Right.
Can
in
you
practice.
do it?
And but basically, you need to note the procedures here. And well, as we have just mentioned, we always start with the company law position, and that is you need to disclose. Yeah. You need to disclose. But then what follows will depend on will be what? Will depend on the articles of association. Well, if your company is, say, a private company, and you have adopted, say, Schedule 2, then that director's presence at the meeting cannot be counted towards the quorum.
Yeah.
And that person and that director cannot vote.
Yeah.
But it is not set in stone, because it is thank you. It is possible for the articles to put down that, well, look, if a director has made declaration of the interest, then he or she can vote.
Yeah.
It is what? It is well, technically possible, but it is not.
Yeah.
But you know that the listing rules will not allow that to happen. The listing rules, I think it's Appendix 3, has requested all listed companies not to let well, that director to vote on that matter. Okay.
So Davy, I
Yeah.
would like to ask, because we always said that the company law is supporting your the practice and then also the procedures. And then so when we advise students, because a lot will be asked about the directors. So when students look into the directors' roles or duties, abilities, obligations, or how in practice, they have to look into various angles.
Right.
Not just follow a very plainly of these subject matters. They also have to associate of the others, because in particular, this CG paper is encompassing everything.
So that's why you have to spend at least 200 hours.
Yes, and it explains why.
Okay, so well, now we are at 6B. 6B. Okay.
It's the governance roles of a company secretary is our profession.
So well, this one well, you can go to many good materials, and I think the good starting point is what is our institute's own publication. I think it's called the Essential Company
Secretaries. Yes.
Well, I use it in my classes.
Thank you. And also, I think in this one of the chapter, it encompasses a lot of points as a company secretaries in various aspects. But that question is just saying that it also has certain practical side that the students have to look into the facts of the case.
Well, but here, well, I think that this question has a pinpoint a practical issue.
Yeah.
Okay, and that is should the company secretary has an executive put this way, can we give an executive role to the company secretary? I think there are well, pros and cons. There are pros and cons. And if you are going to give the executive role to a company secretary, you have to make sure that there are clear-cut different reporting lines.
Yeah.
For board matters, the reporting line, of course, is made to the board chair. And for the executive duties, well, the company will report to the CEO. Okay. Well, of course, in the ideal world, ladies and gentlemen, in the ideal world, you may argue that, well, the company secretary should be totally independent. But we know that in the profession, not just in this profession, but in accounting and law profession as well, we are not going to say to kick out each and every conflict.
Yeah.
The key point is to identify the conflict and to assess, to analyze whether that conflict could be managed.
Yeah.
If it could manage, then we can accept well that conflict.
Yeah.
So well, I wish we are living in the ideal world, but frankly,
certain of these facts are quite common. The CS report to the CEO or the CFO in a lot of those smaller size companies.
And 7A, it talks about succession planning. And now this question mentions the skills matrix. Okay. Well, for example, you can go to HAEX, but you can also go to the Australian listed companies, because in Australia, the preparation of the board skills matrix is required, expressly required by the Australian Stock Exchange. Okay, and here the examiner has found that well, some candidates, they talk about 11 things like directors rotation, removal of underperforming directors. Well, it is not required by the question. Okay, well, B. some degree it's straightforward because one director who is the chair of the AC, and apparently she is the only INET in the board that has the accounting qualifications. So if she is going to leave the board, the company is going to bridge a certain listing route, and we know that the board will have a 3 months time to make good. Okay. Well, 8.8. Well, I think it could what? It could somehow surprise the candidates, because it talks about, it relates to culture, corporate culture. Well, again, to me, it's a pity that our CG code has not put sufficient emphasis on culture. But if you go to UK, if you read the UK code, the Australian code, well, the Australian listed companies, UK listed companies, well, they need to build, it's a duty to build and maintain a healthy corporate culture. So again, this question will serve as a wake-up call for us. Okay. Well, ladies and gentlemen, even though technically speaking, it is not a duty for Hong Kong listed companies to do that, but we could be agreeable that a good corporate culture can help the company. So we should do it, even though it is not expressly required by the code or the listing rules.
But I think this, when we go to the next paper, it talk about a lot of these issues.
Yes, well, stakeholders engagement, 9A, talk about stakeholders engagement. And I could understand why this question is quite unwelcome. It's not popular, okay? Because perhaps stakeholders engagement is not, well, that popular in Hong Kong. But once again, we can see that UK, well, is making a big leap forward. Since 2018, the UK listed companies, they must do stakeholders engagement at the board level, because there must be one director who is in charge of the employees engagement. Okay. Well, in Hong Kong, I think it's too much. If you ask me, well, Davy, do we really need to appoint someone from the labor union to the board? Oh, it's too much to ask. I know it, but there's something what lighter can be done. For example, a few years ago, I was requested by a property developer in Hong Kong to give a town hall meeting to the mid-level executives. I remember there were 600 people in the hall. And well, why that company want me to speak to the people is because it was soon after the Volkswagen scams.
Okay.
So they want me to give a speech to the people to preach the importance of business ethics. So this is one way to engage the employees.
So I think, can I say that for this corporate governance paper, it's not just strictly go to the rules, but everything that you can do something better than the rules or the code's requirement is for the good sake of your own company's corporate governance module or on your framework or on your development, rather than just I just follow the the CG code or the listing rules requirements or the company's ordinance, and then we always said that these rules or whatever, blah, 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 are the minimum requirements. And then you can do better. And then I think in Hong Kong, we have quite a number of, the top tiers or the top 10, top 100. They're doing better than the rules required.
Exactly.
So that is why when advising our students, you are not restricted to just tell what the Hong Kong rules. We always said that, remember, this is an international paper. You can also look into overseas, like the rules you've mentioned or the practice in the UK, that usually we follow that. And then slowly, I think, culture is the Hong Kong is, I think, is also airing that we may need to do something. But we take a lower place, a slower place.
Agree.
Okay, the fourth subjects. The fourth module, boardroom dynamics, is a very new module. It's our new model, and I think quite a number of our students may think that this is just a management subject.
Well, it's a hybrid.
Yeah.
It's a hybrid. It's a hybrid. Put this way, one way to understand this course is how we can benefit from the researches from organizational behavior, from management, and what lessons we can learn from OB, from management, and how we can apply those advanced knowledge to corporate governance. So, well, corporate governance is always multidimensional.
Yeah.
Okay. Well, as you have just said, it is not just a set of rules to follow, and in fact, we have to discard that mentality. Well, CG code. Louisa has mentioned that we can learn. We can always learn from the OVC's code. Why? Because corporate governance. Well, you can see it as what? As how to improve, how to enhance the quality of the decision-making process.
Yeah.
So it is not territorial. We can always learn from the foreign practices. So don't think that there's no point to read the UK code because this is not UK.
Yeah.
We can always learn from our peers. Yeah. Okay. Well, don't waste those 6 weeks time.
Yeah. Make the best use of your 6 weeks.
Because,
memorize the facts well.
Yeah, because you can try to put yourself into the shoes of the examiner and try to think, well, what questions would come up 6 weeks later?
Or look into each of those, the characters mentioned.
Yeah. Okay. Well, let me go to my notes.
I'll have you to go to the next slide first.
Yeah.
It's about the case, and then maybe before you take a break, this is again prepare a briefing paper. So all the students miss this out, you lose your marks. Okay, so it's time for you.
Well, question 1A is very challenging because it asks you what are the current expectations of the boardroom behavior. And if you go to the marking scheme or the suggested answers, you see that you realize that you refer to many, not just Hong Kong materials, but the foreign materials. But what if when you enter into the exam hall, you didn't have time to read those foreign materials? Well, would you be in a different position? Well, it may not be so. Because just the knowledge of the CG code will tell you what can give you sufficient information. Like what? For example, well, one way to make sure one current expectation is that the chair and the CEO they should take different rooms. So that none of them is supposed to cross the line. The board chair will take care of the boardroom matters. And the CEO will take care of the day-to-day management matters. Okay, and that's one way. And the second way is the independent directors, well, according to the code, the CG code, should take the lead in the case of conflict of interest. Okay, so that's why you see a connection between CG, even BD with BD and HKCL. Yeah. Well, look, when a director has a conflict of interest. Okay, and when it is when there is a need to escalate it to a case of connected transaction, you know that according to listing rules, the independent directors must set up an independent committee, and this committee must be advised by independent financial advisors. Yeah. Okay, so this is what you have learned from CG, and you can put it here. So I think if I were, well, of course I'm not influencing your decision. If I were a candidate, I think I would take BD
as the last paper.
Yes, as my elective, because especially if I have done well on company law, if I have done well on CG and CSC, I think very likely I would take BD.
Yeah, because BD is also our capstone subject. Yeah. Okay.
And another before we move on to the next slide, one current expectation is that directors, especially independent directors, they must be able to spend sufficient time, because seeing that position as a part-time post has long gone. That's long gone. Well, not well. The listing rules in Chapter 3, I mean the main board listing rules, in Chapter 3 has already said that directors, especially independent directors, must take an active interest in understanding the company's business. So you don't just perform your role in the boardroom. Well, some years ago, Mr. Carlson Tong, the former chair of SFC, at least in 2 occasions, open occasions, he urged independent directors must what? Must not should not become an armchair strategist. Okay, you don't just sit in your armchair and then think, well, what can I do for the company? You must do your homework. You must understand the company, and well, I think this is one of the current expectations you can put in the answers.
Yeah, so I think this also relates to a lot of the inductions to new directors, company visit, or meeting
exactly.
staff. Also, a lot of these are very related. Okay, next slide.
Okay, 1B.
2. Question 2.
Oh, question 2. Okay, question 2.
Proper team. This is more on OB method.
Right. Yeah. So this is where you can where we can benefit from the advanced studies in OB.
Format. Briefing paper.
Yeah. Don't just throw away your points. Don't waste your efforts you spend in your revision.
Yeah, because I think we do it in our day-to-day work life. Should we go to question 3?
Yes. Well, decision-making process.
Yeah, report. Write a report. So that's the comments from the examiner.
And this question to some degree is easy because if you go to study guide, well, there's one whole chapter on decision-making process.
Yeah.
And you can always put your experience in it.
Yeah.
Okay. Well, for example, let me ask you here, ladies and gentlemen, do you think it is too childish to play the game of the devil's advocate in boardroom decision making? Well, what the devil's advocate will do? You always what? You always question. You always challenge. Is it too childish to do it in the boardroom? But believe it or not, that is what the UK Financial Reporting Council would suggest the UK listed company should do.
Yeah, I think it's in some of those seminars or conferences, always says no questions is a silly question at the board. Yeah. Okay, so go to the next one. Okay, again, prepare a paper. So you see why we have a lot of emphasis. The lowest average marks. Why? Sorry.
Okay, we are now at section B.
Yeah.
Right. Well, talent management. I think in section B, when I first read question 5 and question 6 in this section, my first impression is very simple. Well, if you have studied, spend time study guide, you know what to do. Yeah. Because even though they look like briefcases, but in fact they're straightforward. Yeah. If you have read enough about talent management, if you have read enough about say resilience, then you know how to answer question 5 and question 6. Yeah. And one more word before I give I let Louisa to take over again. I'm sorry that I have overrun.
Yeah, a little bit. But anyway, we'll move on.
Okay. And in one question in this paper asks, should the ComSec to be a facilitator? Yeah. Well, in fact, if you have understood company law well enough, you know that in fact the company secretary should not do more than that, because to facilitate means to make it easy. To the company secretary, of course, should make use of the professional knowledges to make the decision-making process smooth. But you should not do more than that. Because if you actually take part in the decision-making process, you will make yourself a de facto director. And this is not supposed, well, of course, if you have a dual role, if you are ComSec and a director, then of course, that problem is not there. There is no such a problem. But if a ComSec is not a director, then obviously, even from the company law perspective, the ComSec should be a facilitator.
Yeah. So it's just we also said the code is that seek advice.
Yes.
They don't make advice. Directors seek advice from this company secretary. So all these are related.
You advise, but don't get your hands dirty.
Yeah. You don't make decisions.
Okay, so that's all I have to say on my part.
Okay. The next one. 6.
Well, this one is, I think it's straightforward. If you have studied if you have spent enough time on the study guides,
study materials,
right?
All those are there. The answers are you can get from there. Okay, that's all. Okay. Thank you for Dr. Davy Wu's lots of
My pleasure.
comprehensive and then given us more insights in studying in these different questions and that in different models, and then you may see that why we group these 4 modules together, because they are so much interrelated and it link to each other. It helps you to understand from each other.
Yeah.
And that the way we present from company law to CSC to CG and then to BD, and that's why we give you certain of this roadmap. Okay, I know that we have been running out of time and a little bit extend, and then we have done a survey from those candidates of the November examinations, and then giving is the experience of these examinations. I will not go into further details in it, and later that we will present all these in the Institute website, as well as we'll send the notice to students that you can share what those candidates and the responses to these questions. But what I would say is that I would like to look into this. Is still preparation of the examinations. At least 100 to 200 hours are needed to prepare for the examinations. So we have a very high response, 90%. Almost 90% they think that we should do it. So it interprets that we have to do a good time management, and you plan, look into your syllabus first, and then look into the study outline, those chapters relating to syllabus. Then you can split those sessions and then do some thorough reading after your skimming of the points of the syllabus. And so still 200 hours, and then do some study. Still, this is the gold standard to study your papers. So the last one is that we just have a very quick wrap up. How to prepare for the forthcoming examinations. How to start from syllabus, because you need to know what are the contents that you will be assessed and tested. And then check with the examination paper structure so that you know that how you will prepare and give your answers. And then look into the online study materials. Yes, we know that our syllabus is very wide and with the breadth and the depth, but please remember you are participating in the professional examinations. It's not just an academic learning. And so 200 hours, and that is our recommendation as a minimum. And also you need to attend, we just quote because we are launching some of the exam technique workshops, and that certain of them will be online or recorded later, and then you can look into it. So when to start, because just like company law, for example, or the listing rules is very thick, you can't just remember it line by line, page by page, but you need to have some reading skills, skim your online materials, and then you divide them into sections. And then afterwards, because we also have a section on how to maximize the use of the online study materials. They have good insight or guidance, is that you can make notes, you can highlight, you can do word check so that you can check with all those relevant words, like directors, it can all over the place, or company secretaries. And so all these will help you to link your learning, those key points together. And that it helps you, you need to develop a big picture in each of those sections. And then the last bit is that read the past papers, try to attend with some exam, the answer plan with some bullet points. So with these bullet points, it's your test, a test to yourself, whether you are answering the questions, and then you won't be deviate, and then have you missed the key words in your questions. So all this is that we just give a snapshot here. And so certain important days for our candidates, the enrollment of the June examination is 31st March, and then we have some of the learning support to you. And so the around the corner is the exam technique workshops with 2 hours briefing, and then you can decide whether you want to do a short mock exam and do your own answers, and then our tutors of the modules will mark your papers, and then he will give another hour collectively to all those participants of the how they answer the questions and then walk through with you. I think that this may help before you walk into your exam center to prepare your answers. So these are the examination timetable. You can look in from our website, and certain of the learning support, please check with our website, and then you can have all this information. And finally is that if you are not taking these modules, but you are taking the other accounting and management modules, we have another session on the 23rd of March, and that we'll walk through similarly each of those exam questions with the examiner's comments. And then I would like to say that, yes, we have a freebies to you. It's on the 13th of April. There's a corporate governance for listing in Hong Kong. It's a webinar. It's particularly free of charge to our students. And then we'll put up the notices very soon in this week. If you want to know more about the listing and IPOs, so you are welcome to join this session. It's also another English session. And if you want to know more, to share the first batch of students who have got good results, and then we have another student sharing on the 19th of April. So stay tuned, we'll send the notices to you. April is a very busy month. The institute is going to change name, and then we will have a students forum to explain to our students of this name change, the meaning, why we change, and then maybe what the benefits are in future, that how you link to this new name of the institute, how you present yourself as the charter secretaries and the charter governance professionals in Hong Kong as well as China, and also link to the international arena. So all these are forthcoming, and then we may have more, so stay tuned. And these are the dates for the forthcoming exam technique workshops. So you just check on our website. So if you have any questions, I know that because it's too much information we want to share, and that Dr. Davy Wu would like to, he's just like teaching, try to link everything together and give you a very good snapshot. So all these are the medias, and then you can know more. So I will say good night to all our students here, and thank you once again.
Thank
okay?
You.
Thank you. Bye-bye.
Bye-bye. And good luck. Good luck with
good luck to you all.